Negligent or not negligent, in the courtroom, it's the lawyer's burden to prove this one way or another to a judge or a jury. In the eyes of the media, the world of law is very familiar with this simple little phrase. However, when actually placed on a case, this phrase is anything but simple. I'm here in front of the law school of Golden Gate University, where I'll be talking to Mark Fong, Senior Counsel of Minami Tamaki LLP in San Francisco, California, where he reveals that an abundant amount of detail and effort is put into every single case, much of which the average person has no idea. So Mark, can you start off by explaining really what you do as your background and what types of cases you typically handle?
I am a trial lawyer. I have 29 years of experience, and my emphasis is personal injury. I handle catastrophic injury, wrongful death cases, defective products, medical malpractice, and I also do some general civil litigation, but the emphasis of my practice is all on injuries.
And you mentioned that there's a ton of detail that goes into every single case, but really what types of detail are we talking about here? And what happens if, let's say, the jury gets the detail confused and doesn't understand it the way you intended?
I would say that as lawyers in general, we all are detail-oriented people. Trial lawyers are especially detail-oriented because we have a limited amount of time to present our case in front of a jury, people we've never met before, and we have one chance to convince them that our side is right, at the same time as the other side is trying to convince them that our side is wrong. And to add to the pressure, we represent the plaintiffs, so that means that we have the burden of proving our case. So if we don't prove our case to the satisfaction of the jurors, we don't win. So I always operate under the standard, the personal standard, that the case and the evidence that I put forward has to be clear enough so that my mother would understand it. And that means it has to be simple, crystal clear, no ambiguity, and it has to be presented in a way so that it is easily understood and will be visually and hopefully emotionally appealing. So the downside is, of course, if you don't do all of these things, the jury won't understand your case, and if they don't understand your case, you lose.